Hey, I want to thank Victoria and everybody at the AOA for having these presentations. I think it's very important that landlords, especially in the last couple of years, really try to keep up to date on what's happening. The more that you know and the more that tenants know what each responsibilities and duties are, I think the more it benefits everyone. So I'm glad you came out here. I'm glad AOA is setting up these presentations, and that's why I like to appear. I like to make sure that people out there know what their rights are and what their duties are, because I think it does solve a lot of problems if people know what they're required to do, and on both sides, the landlord and the tenant. Today we're going to be talking about terminating tenancy, and this presentation, the slides that are up on the screens, will be available on my website. That's why we have it on the screen, so you can always go there. I will also send a copy of it to Victoria at AOA, so she has it. So don't feel like you have to fiercely take notes. If you want to take notes, that's great, but you will have the information. You can always download the presentation so you have it in front of you. So why don't we get started? Also, we're talking about other things. Another thing that I'm doing is writing a book on reverse psychology. So please don't buy it. That was a joke. That was a joke. I always like to start these presentations with a joke. So here's what we're going to be talking about today. Basically, how to serve the proper notices and the common pitfalls, the limitations on terminating tenancies, and navigating evictions in 2022 and beyond. But a couple things. During the COVID years, from 1920 till today, there has been 17 new laws that have passed that affect your landlord-tenant relationship. There's laws from the federal government, there was laws from the state government, there was laws from the county, there was laws from each particular city, might have passed their own laws. The court also passed their own regulations. And so you have this gigantic hodgepodge of new laws that were quickly drafted, horribly drafted, and it's just been a real struggle for me and my office, and I know other attorneys, to try to wrap their heads around all these new laws, because a lot of these laws conflict with other laws. You're not sure which law is going to take precedence over other laws. And because it's happened so quickly, these laws, and some of these laws appear for maybe 6 months, a year, and then go away, there really hasn't been the case workup in the courts to determine what these laws actually mean. So when I'm reviewing a lot of these laws, I basically look at it with my staff and say, okay, what do we think these words mean? Because sometimes I have no idea, because it's so badly drafted, what the heck the words on the piece of paper in this statute means. And then if we can decipher what those words mean, is, well, how does that, if it conflicts with a San Diego law or a state law or some other federal law, let's say, how does that all intertwine? And so it's been a real nightmare for me. And if it's a nightmare for me, it's got to be even 10 times worse for you guys to try to figure out what's going on. So at this point, I'm going to try to clear up a lot of these laws and give you something concise. Now, I'm trying to make this as concise as possible, but because there's 17 different laws, it's going to be a lot more difficult for me to explain these things than it would have been maybe 2 or 3 years ago. And so I don't know how to solve that, except for me trying to do the best I can to try to tell you what all the laws mean. So at least it's on your radar that, hey, I remember Franco saying something about this. I should talk to someone else, maybe an attorney or someone else, to make sure I'm correct about this. Because if it's not on your radar, you're not going to worry about it, and then you're going to get yourself in trouble. Okay, so let's see what we can do. So in serving the proper notice, we're going to figure out what is the right notice to serve these days. What was right a couple of years ago is no longer correct. So we need to start thinking about that, how to serve a notice, the do's and don'ts, and the common mistakes on the notices. So let's start when can you serve a particular notice? You can serve a 30-day notice if your tenant has a month-to-month agreement that's less than 1 year. Okay? So what if it's 1 year? Well, then you can't serve a 30-day notice. You'll be forced to serve a 60-day. So anything less than a year and your tenant's on a month-to-month agreement, you can still serve a 30-day notice. Now things are going to start changing a little bit. On the 60-day notice, if your tenant's on a month-to-month agreement and they've been there for more than 1 year, okay, there was a new law called AB 1482, the Tenant Protection Act of 2019, which basically said any tenancy that's lasted more than 1 year, you need to give a 60-day notice. Okay. Well, what if the tenant was living in one unit for 9 months and then they moved to another unit in your same building? Okay. I would still view that as the same tenancy, it might be at a different location, and just to be safe, to be conservative, if the combined dates, 9 months plus 6 months in this new unit, but in the same building, you would give a 60-day notice if you were trying to terminate that tenancy. If you want to give a 60-day notice with cause, and now if you're in the city of San Diego passed its own regulations, the right to know regulations. And then we also have the Tenants Protection Act of 2019, which is referenced up here as AB 1482. So I'm going to refer to it as AB 1482, which is the state law. So if you're in the city of San Diego, not Encinitas, not Lemon Grove, but if you're in the city of San Diego, I'm going to tell you certain regulations, okay? And then there's state regulations. Now the question becomes, well, if I have a unit that's in the city of San Diego, which regulations apply? The city's regulations dealing with how to kick out people, or the state's regulations? I don't know the answer. So what I've been, because it's very unclear, the state regulation says, well, if you have a city that's passed its own regulations and it's more restrictive than the state, then you should follow the city regulations. Well, the city regulations are more restrictive in certain aspects, but it's less restrictive in other aspects. And the case has never gotten in front of a judge to basically say, no, this is the law that you need to follow. So what I'm telling my clients is basically, let's follow both laws to be conservative. Because you don't want a situation where you follow the city law and then some judge determines at a trial down the road that, no, you should have followed the state law as well. Okay, so they're very similar. So at this point, I'm going to basically tell you, if you're in the city of San Diego, you're going to follow the city of San Diego regulations as well as the state law. If you're in some other city in the county of San Diego, okay, you need to follow the state law. Now, different cities might have different regulations as well. Well, hey, I'm up in Del Mar. What's there? There might be specific things. So that's why it's become a lot more difficult for us in the office when you call in for us to vet exactly what law applies to you, what federal law applies to you, what state law applies to you, what county law applies to you, what city law applies to you, and what court regulation applies to you. So we're going to be asking a lot more questions than we normally do in the past. So, but if you have units in San Diego, focus on what you need to do for the city of San Diego. Everybody else, look at 1482. Okay, for 60-day notice for cause, if you're on a month-to-month agreement more than 2 years, you have to give cause if they've been there more than 2 years. Under the state thing, if they've been there more than 1 year. So what does that mean? After a tenant's been there for more than 1 year, you have to show some type of cause on why you want to kick them out. You can't just say, as you might have in the past, you know what, I don't like this tenant anymore. I just want to remove them, and you would just give them a notice. After the first year mark, you can't do that anymore. You have to give a cause, okay? And we're going to go over those causes, okay? So what can you do to get, not around, but maybe, limit the amount of laws that apply to you? If you have a lease, okay, or you're on a month-to-month agreement, and you want to terminate that tenant, try to terminate the tenant prior to the 1 year mark. Does that make sense? If you're drafting a lease, don't make the lease for 1 year. Make the lease for a couple days short of a year, okay? If you make the lease a couple days short than a year, then all these at-cause regulations, reasons why you need to kick out people, doesn't apply to you, okay? So at the 1 year mark, if you think, you know what, this has been a good tenant, I'm going to keep them, great. If they've been a miserable tenants, right, they're disturbing other tenants, they got a dog, you really don't want them to have a dog, or, et cetera, okay, you can terminate their tenancy, okay, with the expiration of a fixed term lease. So, hey, your lease was for 11 and a half months. Because it's less than a year, you can terminate the lease by not giving any notice because the lease is less than 1 year. If you're on a month-to-month agreement, right, prior to the 11th month, you could serve a 30-day notice with no reason and say, I need you to move out, okay? So if you are in the habit of giving a 1 year lease, don't do that anymore, because as soon as I see that 1 year lease and you want to kick the person out, I'm going to be like, we need to find a reason to kick them out. Does that make sense? If it's less than 1 year, great. We serve them a 30-day notice, or we just wait for the expiration of the less than 1 year lease, if that makes sense. Okay, so what if you want to kick out somebody on a post foreclosure? If you're evicting a tenant, you would have to give a 90-day notice. Now, I don't know if you know, but if you're kicking out the owner, the previous owner of the house, you would just have to give a 3-day notice. But if the house has a tenant in it, you would have to give a 90-day notice if you bought a house in post foreclosure and there's a tenant in the unit. And you might have to give a cause. Give a reason why you're kicking them out, okay? Also, Section 8, if you're trying to kick out a Section 8 tenant, Section 8, for people who don't know, is a federal program that basically the federal government pays a portion of the rent to you as a landlord, and the tenant pays the other portion. So if you have a Section 8 tenant, and if you would know it if you do, then you would have to give the person a 90-day notice, okay? Fixed term lease, basically, if it's less than 1 year, it can expire, and you can kick them out at the expiration of that. If it's a year or greater, we need to find cause for them to terminate. And obviously, you can't terminate a lease in the middle of the lease unless you have a reason to. Okay, let's move on. When can I serve a 3-day notice? Okay, so the other ones are basically, 30, 60-day notice, and we'll go over those causes. But when can I do a 3-day notice? I don't want to wait 30 days, 60 days, or 90 days. Typically, the typical ones are failure to pay rent. Hasn't paid the rent. Breaching of the lease. Hey, you can't smoke in the common areas. It's part of your lease. You're breaching that. You're using the premises for unlawful purpose. Drug dealing, prostitution, running a business, auto repair shop, whatever it is. Committing waste. Committing waste is basically they're destroying the unit so bad that it's affecting the value of your property. That's what waste is. And the same thing that's kind of consistent with nuisance. The nuisance has to be bad enough where it's basically affecting the value of your property. So, hey, I own this house, but there's 40 million people living in there, right? And there's constant drug activity going back and forth. That's affecting the value of your property, okay? So it has to be significant. And also illegal subletting and assignment. What's happening a lot these days, as you guys probably know, hey, I have an apartment, a 2-bedroom apartment, and there's 12 people living in there, and the tenant's been subletting rooms out to other people, subletting living rooms out, subletting anything that they can. So that would be most of the instances in which you can use a 3-day notice to evict somebody, okay? So let's say you have your 30-day, 60-day, and 3-day notice, you need to serve it. How would you serve this? Now, you can serve it, you can have someone else serve it, a professional process server. Let's say you're serving it. You can go up to them and hand them the document, okay? If you have multiple tenants, if you serve one tenant, it's serving all of them. Does that make sense? So let's say you have 3 people on your lease, you serve Mary. Once you serve Mary, the other 2 people are also considered serve, okay? Now let's say you go to the door, you knock on the door, and none of the tenants are there, but some other person's there. Bob's there, but he's not a tenant. Bob is Mary's, let's say, boyfriend. Okay, one I would ask for, is any of the tenants there? No, they're not. You can hand a copy to Bob, because he's an adult, an adult meaning over 18, and then you mail a copy to the tenants at the residence. Okay, that's called substitute service. I'm substituting Bob for the tenant. I'm handing him a copy as an adult, and I'm mailing the tenants to their address a copy of the notice. Now, the other thing you can do is post and mail. Now, when personally handling somebody, before you can substitute serve, you need to personally serve, okay? And before you can post and mail, you need to personally serve and then substitute serve, and then you can post and mail. Now with substitute service, if you know where they work, you need to try to serve them at work. So let's say Mary works at the In-N-Out Burgers down the street. You would have to go down there and try to serve her there. Now, if she's not there for whatever reason, you can leave it with somebody, right? Because there should be an adult working there, a supervisor. Hey, this is for Mary, and then mail a copy to Mary at her address. So you can substitute serve at the premises or at the person's work. Well, what if I go out there, I don't knock, and I just posted the notice on the door and mailed them a copy? You didn't do it right, and you will lose. Why? Because you need to try to personally serve first. You didn't try. You didn't knock on the door and wait for people to open. You just posted it on the door. So that's a mistake. You need to knock. Now you can say, I knocked, nobody answered. Okay, do you know where she works? Yes, I do. Go serve her at work. Okay, let's say I don't know where she works, right? She changed her job. Okay, you try to personally serve it. You knocked on the door, nobody came. You don't know where she works, so now you can post and mail. Post a copy on the door and mail a copy to the residents, and that's considered service as well. So again, it's very important because there's people lose cases about this. They immediately post and mail. They don't do the personal service. They don't do the substitute service, right? I went there, nobody answered. Well, do you know where she worked? Yes, I do. Did you try serving at work? No, I didn't. I just posted a mail. You lose. Okay? They're very strict about this. As you guys know, the courts force the landlords to do everything perfectly correct because they want to make sure, because unlawful detainers, evictions, are very expedited process. They were in the past, not anymore. Expedited process, and they want to make sure, if we're going to, the legislature want to make sure, if we're going to kick out people, we want to make sure landlords do everything perfectly, okay? Because if there's a bunch of mistakes, a person never got a notice or whatever, we're kicking people out on the street. So that's why they kind of force the landlord to do everything right. The tenant can basically do whatever they want in responding, and it really doesn't matter too much. So that's how you serve a notice. And any questions and stuff like that, we'll handle them at the end of the presentations. Just write them down. Okay, additional requirements for Section 8 tenants. These are federally subsidized tenants. Okay, you also have to serve the notice on the Section 8 representative, right? So everybody has a case worker or case manager for your Section 8 tenant. You need to serve them. Well, what if I don't? Well, you're going to lose. Because when you call my office, we're going to ask you, I served the 60-day notice. Okay, great. Section 8, great. Did you serve the representative? No. You need to start over again and serve a new 60-day notice. So you have to serve the representative as well. Okay, so don't forget that. You also have to serve what's called the Violence Against Women's Act notice. It's a documentation, it's several pages long. So that has to be attached to your notice as well. Okay. The CARES Act. The CARES Act was the federal law that was passed when COVID first hit. Okay. And you might be subject to the CARES Act if the mortgage on your building is backed by the federal government. See how crazy this is? So if you have a mortgage that's backed by the federal government, okay, Fannie Mae, Ginnie Mae, one of those, then you're required to give a 30-day notice. So when you would call up my office, hey, what's a building, blah, 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 who holds your mortgage on your property? What? Why do you need to know? We need to know whether or not this federal law applies. Because if it's applied, we can't do the 3-day notice, we'd have to do a 30-day notice, okay? Well, what if, I don't know if it applies. There's an actual website out there that you can go onto the website and punch in your information, and it'll tell you whether or not the federal government backs your mortgage. So this is how crazy it is. Okay, let's keep moving. Well, how do I calculate the 3-day period on a 3-day notice? Or any notice, actually, but I'm going to focus on 3 days, right? So if you serve it on Monday, you don't count Monday. So you don't count the day that you serve. So the first day would be Tuesday, Wednesday, expires Thursday, so you could file an eviction on Friday. Okay? Weekends don't count. So let's say you serve it on Thursday. You don't count Thursday, so you count Friday. You skip Saturday, you skip Sunday, Monday, Tuesday is your third day, so you can file something on Wednesday. Well, let's say Memorial Day. Memorial Day typically falls on a Monday, and you serve it on Thursday. Thursday doesn't count because it's the first day. You have Friday. Friday counts, day 1. Saturday doesn't count because it's a weekend. Sunday doesn't count because it's a weekend. Monday doesn't count because it's a holiday. So your second day is Tuesday. Then Wednesday is your third day. We file it on Friday. Does that make sense? Well, why is this also important? If you serve a 3-day notice to pay rent or quit, and you're thinking, well, I served it on Thursday, Friday, Saturday, Sunday. Sunday was the last day to pay. And she comes to you on Monday, I want to pay rent, and you say no. You screwed it up, right? Because if it was Thursday, Friday, Monday, Tuesday, she had until Wednesday. So if it came out at trial that you refused payment from her on Monday and she had until Wednesday to pay, you're going to lose. Does that make sense? So it's important to know. So no weekends, no holidays, don't count those, and don't count the first day, the actual day that you serve the person. And the same thing with 30-day notice. 30-day notice, you don't count the first day, so the first day is the next day. Then the last day can't fall on a weekend or a holiday. Okay? Do's and don'ts of 3-day notice to pay or quit. If they come up with the full amount of rent, let's say through the 3-day notice to pay rent or quit, you have to take it. You can't say no, okay? If there's evidence the tenant tried to pay the full amount of rent and you rejected it, you're gonna lose. You can accept partial payment, but no, if you accept partial payment, it will invalidate your notice. So let's say a tenant owes you $8,000 and they come up to you for, here's $100. If you take the $100, it invalidates your 3-day notice. Now sometimes, let's say the tenant owes you $8,000 and they come up with a check for $4,000. I would recommend keep the $4,000, turn around, serve a new 3-day notice for $4K. It's better to collect the money up front, but that's your decision. If it's $100, I say it's not worth it, right? If it's $1,000, $2,000, $3,000, take it, turn around, and give her a new notice, okay? Don't agree to allow the tenant to be there past the 3-day notice period, or any notice period, right? So the 3 days expired, or the 30 days, or 90 days, tenant comes to you, can I just stay another couple of weeks? Yes, you can. You just waived your notice, because your notice says, after the 3-day, 30-day, 60-day, 90-day, I want you out or I'm going to kick you out. So if they come to you and say, no, can I stay a couple weeks? No, you can't. You need to move out. or else I'm going to start legal proceedings. Okay? So don't waive your right, what you're telling them in the notice. What if you give a notice, 3 day, 30 day, 60 day, and the notice, the tenant leaves? Okay, great. They still owe you $8,000, or they still owe you X, Y, and Z. You can still take them to small claims court to collect that amount. You won't be able to take them to, well, you could if you want to go to Superior Court, but I recommend going to small claims court. This brings up another issue. Here's how crazy the law is. If you're trying to, let's say a tenant leaves and the tenant owes you rent from going back to 2020, okay? The law is set up right now where you can sue them in small claims court if you have a huge amount, let's say $20,000, but it breaks up the time periods of when you can request certain rents in small claims court and when you can't. It's a complete nightmare, okay? So I'm not going to get into those laws right now. Some of the judges in small claims court have been interpreting that law differently than the way I would interpret it and other attorneys. So if they owe you a substantial amount of money, right? Small claims court right now is just allowing you to go through small claims court for a period of that time, 1 year, and the rest are saying you got to go to Superior Court. So what I'm telling my clients is if they owe you a chunk of money, just file an action in Superior Court. They owe me $20,000 unpaid rent. Forget small claims. Let's just file in Superior Court and avoid all the issues that's going on in small claims court. But if you wanted to, and your amount is greater than $10K, you could sue them in small claims court for more than $10K for quote unquote COVID rent. Rent that was accrued during the COVID pandemic. Okay, let's keep going. Do's and don'ts during the 30, 60, 90 days. A lot of it is just the same. Don't accept rent past the expiration of that notice. So if your 30-day notice expires in the middle of the month, calculate per day what the rent is owed up until the end of that notice and only accept that. If you accept one penny past the expiration of the notice, it waives your notice. 1 penny, okay? Some games that tenants sometimes play is, let's say you have an automatic deposit for your tenant, and they, without you kind of knowing, they deposit $50 into your account. Now the notice expired 30 days ago. You need to either block them from doing that. If you're not able to block them, then you need to just keep an eye on your account to make sure they don't do that. Because there's been a couple times, middle of trial, all of a sudden the tenant says, oh, I deposited $50 3 months ago. I looked at my client, do you know anything about this? No, she really didn't catch it because all of the tenant's rents go in there and wasn't keeping an eye. If the tenant determines that the $50 has been there for a while, the judge is going to claim that that amount has been accepted by the landlord. Remember, you accept $50 past the notice amount, you're going to lose. So keep an eye on those automatic deposits. If you can stop them, great, stop them. If you can't, for whatever reason, sometimes clients say, I don't know how, the bank can't let me stop these people. I would have to shut down everything. I don't want to shut down everything. Okay, once a week, I need you to look at it and see in case she deposits $50 or whatever. If she deposits $50, I need you to write up a quick little letter saying, I don't accept your $50. Here's a check for the $50 back. And that means you're basically telling her, I don't accept the $50. And then you'll be okay. Also, if it's a notice to move out, you need to inform the tenant that they have a right to a final inspection so they have the opportunity to get their security deposit back. A lot of newer rental agreements already have it in the rental agreement. Hey, by the way, when you vacate, you're entitled to a final inspection. Please contact us if you want one. If you don't have that in your lease, you need to reach out to your tenant and say, hey, you have an opportunity to have a final inspection. Do you want one? Yes, I do. Okay, great. Let's set up a date and go in there. And when you do, during the final inspection, you basically tell the tenant what they need to do to get their full deposit back. So you go in there, well, you got to make sure you clean the kitchen. You got to make sure you professionally clean the carpet. There's 2 or 3 holes in the wall. You got to fix those holes, blah, blah, blah. You do all that stuff, you'll get your deposit back. You work up a list and you give it to her. Oh, okay. And then once they move out, you go through. If they fail to do certain things, you can charge for those things. Okay. What if I don't give them an opportunity to do this final inspection, right? I never contact them. It's a duty of the landlord to contact the tenant and notify him or her that she has a right to this final inspection so she can do the work to get her full deposit back. If you fail to do that, then she has an argument to say, you know what, Your Honor, the landlord never gave me an opportunity for a final inspection. I didn't know about it, didn't notify me, and now he took $1,000 out on a secure deposit. The judge could be like, you should have told her, you didn't tell her, you need to give the $1,000 back, even though there were legitimate charges. Okay? Let's keep going. 3-day notice to perform covenant or quit time period. Perform covenant or quit is basically, hey tenant, you failed to do something in your lease. No dogs, no smoking, Stop hassling the other tenants. Stop subletting. You're failing to perform a covenant, a paragraph of your lease. So what shouldn't you do? If it's a monetary breach, hey, you owe me late fees, you owe me this, whatever, you have to accept the full amount of money, okay? If it's basically, you have to give the tenant an opportunity to cure the breach. Hey, I want to do this. You can't just say, hey, you have a dog, here's your notice, you're out. Well, I got rid of the dog, I don't care. You're still out. It doesn't work that way. If they cure the breach, they cure the breach. Don't accept payment past the 3-day period. As we talked about before, any acceptance of rent is going to be considered a waiver of the notice to her, because the way the law looks at it is, why would you accept rent for a time period after the notice? Because in the notice it says you want her out after the 3 days. Well, if you accept rent for a month after that, you're basically saying, no, forget that notice. It's okay for you to stay another month. Okay? This happens sometimes. Don't make yourself unavailable to communicate with the tenant. Okay, so the tenant needs to do something because you notified them of a breach, and then you make yourself scarce, right? Don't do that. It doesn't look good. If we go to trial and the tenant goes, I left 10 messages for the landlord because I'm supposed to do X, Y, and Z. I couldn't finish what I needed to do because of the breach because he never got back to me. That's not going to look good. So if they try to reach out to you because they're trying to accomplish something, you need to make yourself available. Okay? Common issues with the notices. A lot of notices people have are old and they're no good anymore. Just throw them out. Unless you got something from an attorney in the last 6-9 months, don't use those because they're probably not good. We get countless amounts of notices in our office. Hey, I want to file an eviction. And you see this notice is probably 10 years old, 20 years old, 30 years old, from 1920. I've seen everything. It's bad, okay? So what I tell the clients, look, if you want to do something at this point, call the office. I'd rather have you call the office. We can tell you this is the proper form to use, as opposed to you waiting 30, 60, 90 days, finally coming to the office and say, oh, here, I'm ready to start an eviction. No, you're not. Your notice is bad, and you need to reserve the notice. It's horrible. It's horrible for us telling clients that because, oh, this tenant's horrible, horrible, horrible. Well, this notice is old. It's missing this language. It's invalid. You need to do it over again. So all your notices are bad unless you got them recently, let's say in the last year. Okay, so it requires certain abandonment language. Abandonment language deals with the personal property that's left. It has to be on the notice. If it's not, your notice is no good. Somebody has to sign that notice. A lot of times we get notices that aren't signed. It's not going to work. Either you, your property manager, somebody needs to sign that notice. Okay, you have to have the full correct legal address on the notice. Sometimes we get notices, and I know landlords get really busy. Wrong zip code. It's the wrong zip code. Or we look up the address and wait a minute, this isn't the right street. You're actually on a corner and the legal address of this is actually the other street. He goes, well, I've been doing that for 40 years. That's not the right address, right? So you got to make sure the address is correct and it's the full address. Don't leave out the city, don't leave out the state, don't leave out the zip code. If it's not the full address, it's going to be invalid. And I know sometimes you're rushing, you're just trying to slap it in there and you leave out, San Diego, California, that's it. I don't see the zip code, it's not going to work, and we're going to have to do it again. Rent periods have to be correct. Here's another common problem, right? Hey, sometimes people don't start the rent on the 1st of the month. It's the 3rd to the 3rd, or the 10th to the 10th. I'm not talking late period. I'm talking about when is the rent due. If the rent's due on the 3rd, you can't just put January to February 2022. No, you need to put January 3rd to February 3rd, 2022, right? Or February 2nd, right? So you got to have the right time period is in there, and you have to have the right date, the right number of the date on there. Does that make sense? So if the rent's due on the 1st, it's got to be January 1st through the end of January, right? If it's on the 3rd, January 3rd to February 2nd, and all the way through. And you got to have numbers, meaning you can't just say January, February, March, and that won't work. So make sure your rent periods are correct. If they're not correct, we're going to lose. Okay, or we won't lose. We won't file the action because we know we're going to lose. Okay, let's keep moving on. Limitations on terminating tenancy. So this has been the biggest area of law that everybody and their mom is trying to change to affect your ability to terminate a tenancy. Okay, so the two laws we're going to be covering right now is the big one, the City of San Diego, right to know, that we talked about. Okay, and the Tenant Protection Act of 2019, which came into place on January 1st, 2020, which is basically anything over a year. Now I'm telling you guys, we're just gonna apply both of them if you're in the city of San Diego. If you're outside the city of San Diego, you're just looking at AB 1482, okay? But the restrictions are fairly similar.
We're not talking about whether it's applicable to you.
Yeah.
There's some properties that are exempt, and we're not discussing it today.
That's a good point. I'm glad you brought it up. In AB 1482, there's certain exemptions to that. So your property might fall under that exemption, okay? So let's say it's a single family home and it's owned in a trust. That's probably, and if you did the proper notice, that's probably gonna be exempt, okay? So there's different exemptions that could apply under 1482 and even the city of San Diego. I'm not going over those exemptions, okay? If you think your property may or may not be exempt, you need to talk to somebody, an attorney, and say, hey, I have this property. This is where it's located. This is what it looks like on the parcel. Am I exempt, right? And if they say yes, great. If they say, well, no, it's not, or they might say, no, it can be, but you need to serve this particular notice, they can give you advice. So if you're not sure, you need to talk to somebody. But let's assume it applies, okay? If you own an apartment building, let's say more than 2 units, 99% it's gonna apply to you. Let's put it that way. If it's a single family condo, depending on what the situation is, maybe even a duplex, sometimes it may not apply to you. Does that make sense? But if you own an apartment building, a fourplex, threeplex, and above, it's going to apply to you, okay? But we're gonna cover both. Okay, City of San Diego right to know ordinance, okay? So when can you kick out people, okay? Typically the same for cause type situations, failure to pay rent, they violated some clause of the rental agreement, they're causing a nuisance, illegal use, and refuse to provide access. Those are still viable options, okay? Another one is refusal to renew a lease. So what does that mean? They're on a lease and you want them to sign a new lease, okay? And you go to them, hey, here's your new lease, I need you to sign it. I don't want to sign it. It's like, okay. So you can kick them out if they refuse to sign the new lease. So basically the new lease has to be on similar terms, okay? Contains similar provisions. What does that mean, similar? I think if you take your old lease and kind of use it the same, or maybe you just update it, I think you're gonna be okay, right? But if you have a lease that's a half a page long and all of a sudden you want them to sign a 40-page lease, that might not be considered on similar terms. Obviously that's a drastic example, but I don't know what the word similar means. It's not defined, but I'm just kind of throwing it out there. The landlord has to request the renewal in writing. Hey tenant, in a letter, I need you to sign this, please sign this. The tenant tells you to go jump in the lake, we can serve them. You can kick them out as, and that's incorrect, no fault, just cause, is actually fault, just cause. The tenant's doing something wrong. They're at fault, they're not signing the lease, so that's why you're kicking them out. And it applies to any lease agreement that happened, that terminated on or after April 2004. Let's go on. What other things can you kick out people in the city of San Diego? Correction of violations. So basically, let's say you got cited by the city of San Diego. Hey, you need to fix certain things. The important part here is, so you can kick out a tenant because you have to make repairs, okay? But you have to make sure you get the permits before you serve the notice, okay? You have to have all the necessary permits you need before you can serve a notice on the tenant. What happens a lot of time is the landlord serves a notice. Hey, did you get all the permits? No, I haven't yet. I'm in the process of it. Your notice is invalid. We need to wait until your permits all been pulled, and then we can serve the notice, okay? And typically under this, just so you guys know, there's got to be some type of substantial work that needs to be done. So if you get cited, hey, your heater doesn't work, you need to fix it. Well, tenant, you're out. I got to fix this. I got a notice from the city. It's not going to work. It's got to be quote unquote substantial. And typically the work has to last longer than 30 days. And it would require that the tenant get out of the unit. Okay. So you just fixing a heater that you got cited by the city is not going to last 30 days. And it's not technically going to require you to have the tenant removed, right? Or have to move. So let's say you go in there, it's like, oh, wow, there's asbestos throughout the apartment, the ceiling, blah, blah, blah. Okay, you're not gonna be able to perform the work while the tenant lives there because obviously you don't want the tenant to be exposed to asbestos. Or let's say there's a bunch of mold in there. No mold company is gonna allow the tenant to be there while they're cleaning out all the mold, okay? And the asbestos or the mold or whatever other work you're gonna do, it could last more than 30 days. So in that situation, I think you'll be okay under the Tenant's Right to Know Act to say, hey, tenant, I need you out because we need to remove the asbestos, we need to remove the mold, or we need to redo the kitchen, the toilet, the back, the plumbing, the electrical, whatever the issue is with the city of San Diego. It's going to take more than 30 days. We need to get you out. You got to get the permits first, and then you can go from there. Some work doesn't require permits, right? Let's say the removal of asbestos doesn't technically require a permit. So there are limited circumstances where you don't need a permit, where you can basically say, I need to perform this work, and it's going to be worked by an asbestos company, right? They told me it's taking me more than 30 days, and they can't have you living there, so I'm going to give you a notice immediately. That works sometimes. But most of the time, if you're doing something substantial, you usually need some type of permit, okay? Other ways, no fault. So this is no fault now. We're switching. Prior things were the tenant did something wrong, so I'm able to kick them out because they did those things that are wrong. Now it's the tenant didn't do anything wrong, but I still want to get them out, okay? So withdrawal from the rental market. The landlord, you want to remove the unit from the rental market, okay? Let's say it's a condo that you rent out. It's okay because you're removing the whole condo from the rental market. Let's say you want to put it up for sale, right? I'm removing it. Tenant, you need to move out because I'm taking it off the rental market. I'm putting it up for sale. Fair enough. Let's say you have a 4-unit complex, right? Fourplex. In order to use this reason to kick somebody out, all 4 units would have to be vacated, okay? And it could be, hey, I'm putting it up for sale and I want to sell it with no tenants in there, right? And you kick out all the units because you're going to sell everybody. But you can't, on the fourplex, you can't give notice under this reason just to kick out one person and not the other 3. That won't work. But a house, it works. A condo, it works, because obviously you're taking it all off the market for whatever reason. The other reason, owner or relative occupancy. It's either you, the landlord, the spouse, parent, grandparent, brother, sister, child, grandchild, and it's got to be one of those. Well, what about uncle? Uncle doesn't work. They don't like uncles. Aunts, you know, if it doesn't fall into one of those, you can't do it as a reason. Does that make sense? My great-grandmother, no, he's not on there, or she's not on there. So it's got to be one of those reasons, or a resident manager, you want to go into a unit. So it's like, you know what, I have 2 homes, I'm selling one of them, and I'm going to move into the other one. Okay, great, you can do that. Or, hey, I'm going to move into one of my apartment complex in a 3-plex. You could do it. So if a relative is moving in, or you got to get a resident manager in there, this is one of the reasons that you can kick out. Okay. So you notice in the San Diego, before I go into the state, there's only limited reasons. If your reason isn't one of those at fault or not at fault, you can't kick them out. Well, hey, my tenant's being a jerk. He's been a jerk to me and my maintenance person. He's calls me names. Well, in anything that we talked about so far, is there any cause in there that says, well, if the tenant's a jerk and calling you names and hassling the maintenance person as a reason to kick him out? It's not. So that's the problem with listing things of what you can and can't do, because there are going to be circumstances where it doesn't fit into that list. And we're trying to jam it into one of those exceptions. So that becomes a problem. Okay? Now we're going to talk about the state. Now this state applies to everybody unless your property is exempt. Okay? So you can kick them out at fault. The tenant did something wrong. That's what it means, at fault. Default in rental payment, breach of a material term of the lease, nuisance, waste, refusal to execute a written extension, criminal activity, assignment or subletting of premises, refusal to allow the owner to enter. You're trying to get in to make repairs, they won't let you in. Using the premises for unlawful purpose, employee agent's failure to vacate after termination. Employee could be like a resident manager. Hey, you're fired, you need to get out. Doesn't get out. Again, you have 10 reasons. There's a lot of times it's not going to fit in that, and then we struggle. We struggle with the clients to try to figure out a way to get them out. But it does become an issue, but those are what the at fault are. Now the no fault under the state law, you intend to occupy the residential as, like we talked about before. Here's a little bit more, right? Spouse, domestic partner, grandchildren, grandparents. The lease has to be entered into before July 1st, 2020, and it's got to include a provision that allows owners to terminate for cause. How many of you guys, you don't have to raise hands, have a lease that says, hey, by the way, if I want to go in and take it over because I want to move in, or my parents want to move in, or my grandkids, if you don't have it in there, then technically you can't use this reason, which is ridiculous. It's your property. Yep.
In many of the in an addendum for AB 1482 that says this.
Right.
So if you're looking for it, that would be the first place to look.
Right. So if you have a newer lease or you have a new addendum that takes care of 1482, the language will be in there. If you have an older lease, hey, I've been using the same lease for 40 years, it's time to get a new lease. So reach out to the AOA. They have really good updated rental agreements, updated 1482 addendums that you can add that kind of covers all this stuff. So if you haven't updated your lease in the last even 2-3 years, now's the time to do it. Just do it. Bite the bullet. If you have a bunch of tenants, just do it. It will save you so much grief in the future. This does not include the property manager. Let's keep going. This also no fault. You want to take the property off the rental market, you're selling it, right? Or you're going to do something else with the land. And the owner is complying with the following. Let's say this same thing, the city or state or federal government issues you some type of citation relating to habitability that forces you to basically have to remove everybody. That's also, the tenant isn't at fault. You got served with something. Now you're able to use that as a reason to kick somebody out. Go back one screen. You know what drives me nuts? In the San Diego ordinance, there was nothing in there that says, hey, if you were served by a city citation, right, you're allowed to kick out the tenant. You're served with a city citation. City's breathing down your neck. I'm going to ding you $1,000 a day if you don't make these repairs. Then you call me up and says, I got to kick them out. This is before AB 1482. I got to kick them out. I got served with this notice. Well, there's no real mechanism here. You're subject to tenant's right to know. There's no specific reason in there that says you can kick out somebody because they're in violation of the government order. It's ridiculous. So we're there trying to convince tenants to leave on their own. The city's like, why can't you kick them out? I'm like, why can't the city of San Diego have a decent ordinance that allows us to kick out people when you serve them with the government issue? Okay, that kind of got resolved with the 1482 because they specifically said, look, if you get cited by the city, state, federal government, you can use that as a reason to kick out people. That's just my little pet peeve I don't like. Okay, other reasons. Let's say you want to substantially demolish or remodel the property. Again, this has a substantial requirement. It's got to be substantial. A lot of times landlords come up to me and is like, well, yeah, it's substantial. I'm going to new paint, new carpet, new tile. That's not going to be considered substantial. That's going to be considered cosmetic. Okay? So it's got to be something meatier. Hey, I'm completely redoing all the bathrooms. I'm redoing the brand new kitchen. I'm scraping all the cottage cheese off the ceiling. I'm, new heaters, it's got to be something that can last 30 days, okay? Putting in new carpeting and painting is not going to last 30 days. You could do the work while the tenant's still there. You work in the bedrooms, and then when you're done with the bedrooms, you go in the living room, you do what you need to do in the living room. So it's got to be something substantial, okay? And it's got to require a permit from some governmental agency, or you're trying to abate some type of hazardous material. Remove lead paint, mold, asbestos like we talked about, and it requires the tenant to remove for 30 days. So when a client comes to me and says, hey, I want to use this exception, I go, whoever you're using, your contractor, he's probably going to have to testify if we end up in trial that yes, all this work that we plan to do is going to take more than 30 days, right? And I require that the tenant not be there. If the contractor doesn't feel comfortable testifying to that, we're not going to be able to make it. Because the other side's going to argue, no, you could have done this in 2 weeks. No, we could have still lived here. And it's going to be a battle of who the judge is going to believe. So unless there's something substantial, I want to be able to point to it and say, look, we're doing all this work and it's going to take 30 days and the contractor feels comfortable, then fine, we'll do that. Okay, breach of lease notice. Okay, so we're under the state law still. We're under the state law. If you serve a 3-day notice, tenant, you need to do something. Get rid of your dog. That's not an emotional support animal. Stop smoking. Get rid of your extra people that you sublet to, right? After the 3 days expire, then you have to serve another 3-day notice, which is the 3-day notice to quit. So the first 3-day notice is 3-day notice to perform, covenant, or quit. Then after that, you give them look, you failed to do what you were supposed to do. You didn't get rid of the dog. You didn't get rid of the extra people. You're still smoking, right? And I'm going to want to know that you have evidence after the 3-day that the dog is still there, that they're still smoking, that the extra people are still there, right? After the 3 days. And then after that, we serve them with a 3-day notice to quit. So it just added an extra notice for us. Terminating Section 8 tenancy. These are federal government programs that pay a portion of your tenant's rent. You have to have a just cause for them under the San Diego law, also under the state law. The CARES Act, which is the federal act which applies if your mortgage is backed by the federal government, requires a 30-day notice, right? And Violence Against Women Act, those documents also have to be attached to your notices. So good times. Let's go on. It doesn't matter if any women live there. You need to just serve it as part of, again, it's a federal law that's out there, not drafted very well. Eventually, everybody kind of determined, you know what, we're not going to mess with it. Let's just add it to every notice. And I think at this point, the courts, even though the language isn't the best in the world, they're basically saying, yeah, we're going to require it on every notice. Okay? We're going to hold questions till the end, or else we're never going to get done. Let's keep going. Just hang on to those. Notice period has expired. Can I kick them out? No. Don't kick them out. Don't lock them out. You still got to go through the court proceedings, even though they're extremely slow these days. And you can't use help methods, self-help methods. Okay. So at this point, we're going to jump into the unlawful detainer, right? And and we're going to kind of go over how the unlawful detainer process kind of changed in the last couple of years. So just kind of refresh everybody's memory, the unlawful detainer was supposed to be a summary proceeding. What does that mean? It was supposed to be quick and dirty, because the way the law is basically set up, and it's been set up in California for at least the last 100 years, is the law used to recognize that, hey, every day that this lawsuit continues, the landlord's not receiving rent, right? Typically. So we want to make sure that a landlord, if the tenants fail to do something or landlord wants the property back, that we make this process as quick as possible. We're going to put a lot of burdens on the landlord, meaning we want to make sure they do everything correctly. They serve the notice correctly. They have the right notice, X, Y, and Z. They jump through all the hoops, but we want them to be able to jump through all the hoops in a quick manner so they get their place back so they can get it re-rented. Okay? That was the rationale way back when. But it's kind of changed these days, right? So these days what's happened is we're still going to give all the burden on the landlord, right? And then we're going to throw extra things on and kind of just forget the whole thing of, well, the reason why we're making this quick and putting a lot of burden on the landlord was because we want to make sure they get their property back as fast as possible so they can re-rent it. So they didn't take off any of the burdens on you guys, but they made the process last a lot longer, unfortunately. So there's generally two types of cases once we get it started. There's a contested cases and uncontested. Uncontested means that the tenant never responded to your complaint. They never filed what's called an answer. They never filed an answer with the court basically saying, here is how I am responding to the landlord's allegations that I did something wrong or failed to pay rent or did X, Y, and Z. Okay. Let's go on the next one. If it's uncontested, okay, they don't file a response, okay, then basically we can request a default judgment, okay? A default judgment is basically we submit paperwork to the court and basically says, look, we filed this complaint. We served them on this particular day. They had X amount of days to file a response. They failed to file a response. We want a default judgment so we can get what's called a writ of possession. A writ is instruction from the court to the sheriff to do the lockout. And then once we get that writ, that instruction, that court order, we give that to the sheriff's department. Sheriff's department gets it, basically order them, go out there to do lockout. Okay, so you file the complaint, you get them served, we file the default, get a sheriff lockout, and then we work on the security deposit. For entry a default, so right now the court is working on probably the end of...
I think the rule said August.
So if I submitted a default for one of my cases back on the end of August, the court is now working on that paperwork. So September, October, November, they're 3 months behind, 3.5 months behind on entry and default. That means the court doesn't have to do anything. They take our 10 pieces of paper, they make sure the names match up, make sure the address match up, stamp something. Literally in the past, I used to do this, and it would take the clerk 4 minutes to do this paperwork. It's taking them 3.5 months, right? So if I submit a default on one of your behalf today, I will get the default entered 3.5 months from now, which is ridiculous because in the past, they could do it they used to allow me to walk it through, right? I would go from the court, walk down to the clerk's department, give them the file, give them the paperwork. I would sit there for half an hour, they stamped, signed it, give me the writ, walk down to the sheriff's department, hand the writ to the sheriff. The sheriff looks at a calendar and says, look, we'll be out there in 8 days. No. Now they won't even allow me to walk it through. They force us to file it electronically, and it's taken them 3.5 months to enter the default. Once we get the default in the writ, it gets even better, guys. Once we get the default in the writ, we get to the sheriff's department. Typically, the sheriff in the past, pre-COVID, used to do lockouts in 2 weeks. Now they're averaging 30 to 45 days. So after you wait 3.5 months, you wait another 30 to 45 days for the sheriff to actually go out there and lock them out. So what does this mean? On an uncontested, you're looking at 5 to 6 months to kick out people in San Diego County. I've talked to some LA attorneys. We actually have it better than them. She's told me that it's taking up to a year to kick out people in LA. Let's go to contested. The contested, you have the extra step, right? They file a response, right? They file an answer or a motion. But let's say they file an answer, then we have to go to trial, okay? So typically they set the trial within 21 days after we request it. And then we go to trial. Once trial's over, we either have a judgment or we have an agreement, a stipulation, right? A stipulation, the parties agree to resolve it in a certain manner. Same thing, those documents are taking.
I think they're in September.
So they're working on, so if I did a trial or submitted a stipulation in September, they're just working on it right now. So they're 2.5 months behind on entering that. Same thing, it's a stipulation. The parties agreed to something. All the clerk has to do is just stamp, sign, check the addresses, make sure everything's kosher, and issue the writ. There's no real extra involvement of the judge. Same thing with a default judgment. The judge doesn't get involved. It's all done by the clerk's office. Some clerk sitting there looks at the paperwork and issues what we need to have issues. Okay. Well, that brings up a good point. Why are we having these huge problems? Here's what's during COVID. My understanding is some of the clerks, not obviously, but got COVID. Some of the clerks retired or quit. And if you remember, around April 1st, you really couldn't kick out people if they were behind on rent. So it was only of April 1st of 2022 that you can kick out somebody for failure to pay rent ever since March of 2020. So what happened on April 1st, there was a huge influx, as you can imagine, of all these tenants that hadn't been paying rent for the last 2 years. All these evictions started getting filed. So there was a huge wave of these evictions. I think the clerk staff was shorthanded. And then once they started getting people, because we started noticing, these new people didn't know what the heck they were doing. We were getting kickbacks that made no sense. Kickbacks meaning we submit paperwork and the clerk kicked it back to us claiming there was an issue. There was no issue. They just didn't understand how to process the paperwork because they were new. So the problem is when we get a kickback, and whether it's our mistake or their mistake, when we tell them, hey, you're wrong, we did this right, and we resubmit it, you get back to the end of the line. So, and then what's also happening is the clerk and the court are making up rules, and unfortunately, they're not telling the plaintiff's bar, the landlord's attorney, that they've changed certain things. So here's an example. Everybody knows all unknown occupants, right? If you suspect other people living there, we can serve these unknown people and we can default them. So when the sheriff goes out there to kick out the tenants, they'll kick out everybody because all these unknown people were served, okay? In the past, the court will allow us to default would allow us to file a request for trial and allow us to default them all the way up until trial, okay? They changed that, but they didn't tell us. So we're setting things for trial, and all of a sudden they kick back to trial and say, well, no, you have to take care of all unknown occupants. And we're like, why? The last 25 years, you've allowed us to default all unknown occupants even after we submit the request for trial. No, we changed that. Thank you for the heads up. There was no heads up. There was no announcement. There was nothing. So all of a sudden you get a bunch of trial requests that are default, that are kicked back. Then we have to wait for all unknown occupants to default them. And typically they have 15 days to respond as opposed to 5 days. So then we're wasting another 1 or 2 weeks waiting for all unknowns so we can default them to set the matter for trial again. Again, this is something that they changed. They didn't tell anybody. So they've done that 3 or 4 times. The other thing that's happening is the court's issuing new paperwork, new forms all the time. They're not telling the plaintiff's bar that they're doing this. The way we find out is we submit something that we've been submitting the same way for 25 years, and all of a sudden it's like, we kick it back. You can't use this form anymore. Why not? We have a new form. Here's your new form. When did you put the new form? Oh, about 3 weeks ago. Well, why didn't you tell us, right? You can't fight with them. So we do the new form, go back, refile it, get back into the end of the line. So that's what's been going on. So a lot of people are getting frustrated. I know you guys are getting frustrated. Plaintiffs' attorneys are really getting frustrated. We're getting to the point where we might all get together and maybe talk to the judge that handles this, as well as the presiding judge. And other things, I don't know if you guys know, in the past, we have 4 courthouses in San Diego County: Vista, Downtown, El Cajon, and South Bay. 7, 8, 9 years ago, they consolidated the evictions from all 4 courthouses, right, to 2 courthouses, Vista and San Diego. So when you had the 4 courthouses, if you own an apartment in El Cajon, you went to the El Cajon courthouse to do the eviction. If you're in South Bay, you go to South Bay, etc. About, I don't know how many years ago, they reduced it to 2, Vista and San Diego. Then about 3, 4 years ago, they reduced it to San Diego. So all 5 million residents in San Diego County, every single eviction is heard in the San Diego downtown courthouse in one courtroom in front of one judge. So when we have trials, they have trials in the morning and they have trials in the afternoon. In the morning, it's basically from 8:30 to 12 and then 1:30 to 5. In each morning or afternoon break, they have up to 25 to 30 trials slated to be heard that morning. The only reason the court works is because a lot of the attorneys work together to settle a lot of the cases. But a lot of times, let's say I'm sitting there for 3 hours, my client's sitting 3 hours, our matter might get heard at 11:55 and we've been there since 8:30. Or we don't get heard and we get kicked into the afternoon calendar. So the client's there at 8:30, we're waiting for 3 hours. They don't have time to hear us, come back at 1:30. So it's ridiculous. So that's what's going on. So like before, as you guys remember, before COVID, usually 45 to 60 days, assuming nothing weird happens, like they file bankruptcy or they remove the action in federal court or do some other crazy stuff. But normal evictions were 45 to 60. Now we're looking at 6 months plus. That's the delays. Let's keep going. Why is it important to settlement? So we recognize fairly early, the earlier you settle, the better, right? Because let's say we just start our case, we file the action, we'll start reaching out to the tenant to see if we can try to settle something. Because as soon as we file the action, let's say we get a sell a week later, great. We know it's going to take 3 months for them to look at that stipulation. But if we settle the matter at trial, but it took us 2 months to get to trial, we lost 2 months. Does that make sense? So if we file the paperwork, as soon as we file it, a settlement, great. Hopefully you can get your place back in 3 or 4 months. If we settle, the later we settle, hey, we settle at trial, which is fine. I always want to settle things. But the trial took 2 months to get to that point. Then we have to wait another 3 or 4 months. So we try to settle cases a lot earlier than we have in the past because the time period has become a lot longer. So we always encourage that. Also, if you don't think you're ever going to collect from the tenant, I mean, there should be a strong motivation for you, like, hey, they're on federal benefits, Social Security, those type of things you can't attach, right? They're on disability. Even if you have $1 million judgment against your tenant, you're not going to be able to collect because those funds that come from the federal government are immune to estate judgments. Does that make sense? So if you know that as a fact in the very beginning, and even though they might owe you $10,000, $20,000, $30,000 in rent, you should be calling me up. And then we always tell the client, like, look, let's just get a move out date and waive all the back rent. Well, why should I do that? Well, we can wait 6 months. You lose another 6 months worth of rent, and then you get a piece of paper saying she owes you $20K, and then you're gonna ask, how can I collect? I'm gonna tell you, you can't collect it. He or she is judgment proof. That's what we say, judgment proof, meaning they don't have the assets, you can't get to their income for whatever reason, or they're just, minimal. So at that point, you should be, yes, do whatever you can, I'll waive whatever I need to, get me possession back as fast as possible. Fair enough? Sometimes clients fight with me. No, that's fine. I'll do whatever you want me to do. I'll throw out my recommendation, right? But after you get my bills and you're waiting 6 months and you're wondering how much longer is this going to take, it's like, well, now we have to wait for a sheriff for another 45 days. What? I'm like, well, we could have maybe settled it, have her move out in 2 months, initially with a stipulation. And if she did move out, great, we would have been a lot sooner in the queue to get the sheriff out there. So settlement keeps your costs down. It makes the possession faster, even though it's a lot longer than before, it's still faster than what it is right now. And also, the likelihood that the tenants, if you do a settlement, the likelihood that the tenant won't trash your unit won't do other bad acts is really, it decreases that a lot if you come to some terms. Now, a lot of times, hey, we do a settlement, but the tenant doesn't follow through. That happens, and it happens a lot. I'm not going to say it doesn't, but sometimes they do move out, which is great. You're ahead of the game. If they don't move out, same thing. You're ahead of the queue. You know, you're still going to have to wait 3 or 4 months if they don't move out after agreeing to a 2-month thing. But if you agree to a 2-month, let's say move out date, right, and you settle it, you know, hopefully there's a good 50% of chance that they're going to actually use the 2 months and move out, and you're going to be ahead of the game. What else? Is there another file? Virtual trials. In the past, because of COVID, it would be all virtual. So basically, you would appear by Microsoft Teams. About maybe 4, 5, 6 months ago, they started doing in-person. So what they have right now is a hybrid. You can either appear virtually meaning through the computer, and they have a camera system going on, or you can show up to trial, show up to the courtroom. So they're doing it both ways. I probably think in the next 6 months, they're probably going to get rid of the virtual and just force everybody to come to court, physically to court. I still like virtual because the client can come to the office, the conference room, kind of spread out, you know, we can talk to each other. They can get up, get a drink while we're waiting instead of being stuck in the chair in a courtroom. So I'm still trying to do things virtually, but I think that's going to go away soon. It does make settlement a little bit more difficult. We're basically talking to the tenant on the phone, their cell phone. Sometimes they don't have a cell phone. The court does provide a court form, a court phone, and a place where they can receive calls. The court strongly recommends settlements because they realize they're overwhelmed. The judge cannot handle 25 trials every morning and 25 trials every afternoon. So they basically tell the attorneys, I want you to try to call the tenant. When the tenant's in the courtroom, is like, I want you to talk to the attorney. I want you guys to try to settle this. And a good 80, 90% of cases get settled, right? The biggest thing you have right now is the effect that the unlawful detainer will have on your client's credit, not your client, your tenant's credit. Does that make sense? That's your biggest, you know, if they don't have the money, they don't care if you have a judgment against them for $10,000, right? They just don't have it. Good luck trying to collect. But they do care that they don't want their credits messed up because right now it's extremely difficult to get an apartment unit in San Diego. Not only is the vacancy rates extremely low, but on top of that, because it's taking so long to kick out people that shouldn't be there in the first place, there's no new units that are available to be rented out. So one of the things that's happening is the tenants are looking for another place. They are really trying, some of them, and they just can't find it, okay? And so when I talk to them about, look, the best thing about the settlement, if you agree to this and avoid going to trial, right? Part of it is we agree to masking, which basically means as long as you don't default, it won't show up on your credit report. Does that make sense? So as long as you move out when you say you're gonna move out, and if we work out some type of payment plan, as long as you stick to the payment plan, nobody will know that it was an eviction filed against you. However, if you don't move out when you say you're going to move out, force us to use the sheriff, or you don't follow this payment plan, right? Then it's going to show up on your credit report. Now, you're always going to have a group of tenants that don't care. I don't care where my credit's already screwed. I have a bankruptcy, whatever. They don't care. But a good percentage realize, you know, if I have an eviction on my record, there's going to be 0 chance of me getting an apartment. So that's the best way I found recently to try to get deals done and get some type of decent enforcement. Sometimes, you know, you could file unlawful detainers and small claims actions at the same time, okay? And so what I try to do when we settle cases, I try to settle everything, right? So if there's other disputes, let's say there's COVID rent. So on April 1st, you can only ask for rent from April 1st, 2022 and into the future. But the tenant still might owe you rent from March of 2020 to the end of March of 2022. Does that make sense? For that rent, you would have to go to small claims court, right? So if you file something in small claims court, what I try to do in the stipulation is not only settle for rent after April 1st of 2022, but also the prior rent as well, so you don't have to go to small claims court and avoid that as well. So that's another reason to do a stipulation, because I can put that in stipulation. If we went to trial, the judge will only award you rent from April 1st, 2022 until we go to trial. Hopefully that made sense. And sometimes universal settlement, I resolve all the issues. Let's say a tenant believes, oh, you injured me, or some other stuff happens, you owe me this, you owe me that. Let's say there's real habitability issues. Yes, there was mold there. I paid 2 months worth of rent. I really shouldn't have paid it. I can try to resolve all the issues, get a general release from everybody, meaning they won't sue you and you won't sue them because we have it all in this agreement. And so you don't have to worry about that they're gonna sue you down the road.